Thank you and good morning, everyone. First and foremost, I would like to commend Judge Ana Maria Ibarra for organizing this Congress on Constitutional Law. That will be impressive, truly impressive. I would like to also salute all the legal experts who have kindly accepted to join us and be part of this very important academic gathering. I would like to also greet and salute the more than 16,000 people who have registered for this Congress. And I would also want to salute all the followers of our broadcasts. As Ana Maria has said, technology has made it possible to bring people together and to make these debates accessible. This not happened in Mexico before. We were in a sort of a mirror sort of game where we were all talking to each other, but it was all the same people talking to each other the whole time. But I have the firm belief that we have to be open to all academic and intellectual sources from throughout the world, and we need to interact with all of them and advance our issues. Mexican justice has much to learn from other countries, but today we can proudly say that other countries also have many things to learn from Mexican constitutional law. This Congress brings together the most important experts of the world regarding equality and non-discrimination. I think this is of the utmost importance, and I am positive that it will be well leveraged by all the people who are attending our Congress, and also by those who will be able to see the recorded versions of our broadcasts. Our debates, we of the highest levels. At this time, I think that there can be no better topic than the right to equality and non-discrimination. All modern societies and all societies throughout time, for that matter, have seen inequality as one of their hallmarks. In spite of all scientific, social, and cultural progress, the issue of inequality continues to be present. And for a certain time, it was thought that the issue of equality was to be solved by only pronouncing equality on black and white and be it enacted through a law. But that is not enough. Actually, that statement of equality has been used in a way to continue to promote inequality, because we cannot provide equality to those who are unequal, those who are suffering structural inequality. And this is why we need to strive for substantive equality. We have to work for public policy, for court rulings, and for affirmative actions that help us level the playing field and to look after and care for those who are unequal so that they can be brought up to substantive equality. So far, inequality has affected particularly certain sectors: women, boys and girls, sexual diversity communities, indigenous peoples, migrants, the disabled, people living with disabilities, the elder, and of course, millions of people who live in extreme poverty throughout the world. So we cannot speak of a true rule of law where all rights are upheld for as long as we continue to have inequality. If a society has financial freedom and all sorts of freedoms, does not aspire to have a homogeneous society. It is not about that. It is about having equal rights. Then the dignity and humanity of each person be upheld and respected, and that no one is discriminated against by reason of their sexual orientation, sexual preferences, ethnicity, or gender. And people who belong to these groups need to see their rights upheld by the laws and by the rulings of the courts. So it is my view that the Mexican Supreme Court of Justice has been working very intensely in shortening the distance, in closing the gap, and in leveling the playing field so that the most vulnerable and discriminated against groups of our country be favored by them. Many of our rulings have been pioneering rulings in Latin America and in the world, and not on some other issues. We have not been the first, but have been the second or the third Supreme Court in the world to have addressed the issues. As you know, our 2011 constitutional reform brought a new constitutional paradigm with it. Thanks to this reform that has been construed by the court regarding the contradiction of the of case law 291 of 2011 states that all human rights, not only those foreseen in the Mexican Constitution, but all human rights that are upheld by all international conventions and treaties to which Mexico is a party, have become a party of all Mexican laws. So by mandate of Article 1 of the Constitution, all the Mexican authorities are mandated to create conditions under which equality and non-discrimination are upheld. This entitlement and this right for substantive equality calls for public policy, calls for affirmative action, and also calls for ongoing oversight by constitutional judges. And this is why in the Mexican Supreme Court of Justice, we have carried out actions to ensure that the principle of equality is upheld. And by that, I would like, I mean a few things. And in the last few weeks, in 3 weeks, the Mexican Supreme Court of Justice ruled on 3 cases. The first, on the first ruling, the Supreme Court of Justice unanimously decided on the right of women to choose, and we have stopped on its tracks the criminalization of women and that was horrible and terrible injustice. Women and girls had been brought to justice before because they had had an abortion, but they were always poor. And I know that this might be troublesome for some sectors, but rich girls had abortions performed on them, but they had never been brought to justice for that. But this decision that we made is not only to the benefit of women with unwanted pregnancies, but is also a way to equalize women of all sectors. On the other hand, the court also established that it is the obligation of the Mexican state to provide free and safe and equal abortion rights to all women and pregnant women in our countries. So we have two sides to this ruling. On one side, we are preventing criminalization of women, and on the other, we are providing for safe abortion. Then there was another ruling that established the protection for life from the moment of conception. Some of the states and the provinces in Mexico used to protect those rights, but they cannot dispose of the holder of human rights. And who are the holders of human rights? Well, those whose rights are upheld by mandate of the Constitution. And the third ruling that is extraordinarily relevant, and without this latter ruling, the others would have not been as effective. Conscience objection is not unlimited. There have to be guidelines and principles to prevent conscientious objection from preventing women to have access to the right to legal abortion. We have seen this in Argentina, in Spain, and in other countries. Conservative groups speak about conscientious objection, and then with that, they prevent women from having access to legal abortion. And it affects poor women because they do not have access to private medical services to practice abortion. So the Mexican Supreme Court of Justice is not voiding or nullifying the right to conscientious objection, but has just provided that it must be applied within certain guidelines that provides it some weight within the rights of all people. So all the health staff or all the medical personnel have a right to conscientious objection, but they will have to follow certain guidelines that will ensure that there will be always personnel who do not have conscientious objection to provide the services. So it is about respecting the rights of all people, and by issuing these three rulings, we are protecting the rights of all people. Another very relevant aspect is the same-sex and same-gender marriages. For several years now, the Supreme Court of Justice has said that it is illegal to limit marriage to only opposite-sex marriages. But now in our country, 24 states recognize same-sex and same-gender marriage. We have made huge progress in protecting sexual diverse communities, and this progress has been made due to the rulings of the Supreme Court of Justice of Mexico. So that also speaks of our commitment to equality. We have also issued several rulings regarding persons living with disabilities. We understand that the disabilities lie not within a person, but within society. And this is why we need to make significant adjustments so that all people have access to all their rights without discrimination. We have also made significant progress on the right of women. We have issued mandates to issue rulings with a gender perspective to attend femicide and to look at the issue of double working hours for women. And we have made significant progress in the substantive equality of men and women. We have also made progress regarding the rights of indigenous people. Many rulings have been issued by the court in order to offset the inequalities of the indigenous peoples. What we intend to do is to close a gap, to create substantive equality and to contribute to all people realizing their highest potential. Women, people who are in the sexual diversity groups, people living with disabilities, people who live in poverty, etc. That is our commitment, our undertaking, and our obligation. And this is what we have worked for in the last few years. Our Congress will take us to a profound reflection on these topics. What do we understand as equality? What do we understand as non-discrimination? What are the tools for the interpretation and construence of the laws? What are the methodologies? What are the realities in our country and the different countries of the world? This will be very intense discussions between scholars from throughout the world. And I think this could be, this could not happen at a better time. I am sure that the outcome of this Congress will be most relevant. Our judges, our scholars, and our future scholars and lawyers will see their ideas shaped regarding the way law and substantive equality operates. I also hope that our guests learn of the work of our court. Today, when we see anti-rights movements throughout the world, when we see very strong movements that call for polarization to trample over the rights of the people, it is of the utmost importance that we reflect on the right of not giving way on any of our rights, not one step back on what we have achieved. It is about the dignity of the people. It is about having an operating democracy. It is about the people having access to all the extraneous traits that will allow people to live happily and in full. I am sure that this Congress will be fruitful and will bring us closer to the people in Mexico and in other countries. Thank you, everyone. And with this, I would like to formally open our Congress. Please receive my warm regards. Thank you, Ana Maria, and thank you for your welcome words, and thank you for your work in favor of Mexican justice. A good morning, good day for everyone. Thank you, Chief Justice Zaldívar, and thank you to all the attendees to the inauguration ceremony of our 7th Congress on constitutional law. We urge you and encourage you to remain in our Moodle classroom so that we can continue with our discussion on the philosophical foundation of anti-discrimination law. Thank you very much.
Welcome you all to this first roundtable of this Constitution 7th Conference on Constitutional Law, Equality, and Non-Discrimination. It is a pleasure to have you all here, and I want to thank for the work of the Center of Constitutional Studies, the Director Ana Maria Ibarra and Daniel, because they have prepared a top panel for this session. We would also like to mention to you that we will be having simultaneous interpretation into Spanish and into English. The Spanish will be through the YouTube and Facebook websites, and into English through the website of the Center of Constitutional Studies. I would also like to remind you all who are here with us that you can ask questions through this chat of the Zoom, as well as from the different platforms where we have chats open for you to ask questions or any concerns. We will take down all those questions. We will systematize them and send them to our speakers. So it will be difficult to answer all of them, but we'll do our best to answer the largest number of questions possible. So without further ado, I would like to introduce the persons who are here with us in this first table. First, we have Professor Sandra Fredman, who is a PhD in law from the Oxford University. Her lines of investigation are guided to the study of discrimination, human rights, and labor law. She's author of different books in the subjects such as comparative human rights transformed, and discrimination law, among others. She has been expert consultant in equality law and labor laws in the United Kingdom, India, South Africa, Canada, Malaysia, as well as for the United Nations Organization. Presently, she leads the Oxford Human Rights at the University of Oxford, where she also is a professor. More personally, she was my professor during the master's degree, and it's a great luxury to have someone who has so much influence in how discrimination law is seen today, that she knows it in depth, and that she's so generous to share her knowledge. It's a pleasure to have you here with us, Professor, and it's a great honor that you are here with us. We also have with us Professor Deborah Hellman, who is a PhD in law from Harvard University. Her lines of investigation are based on the analysis of equality and philosophical justifications. She's author of different books, When Discrimination is Wrong and Philosophical Foundations of Discrimination Law, co-edited with Sofia Moro. She's presently director of the Center of Law and Philosophy of the University of Virginia, where she's professor of constitutional law, juridical theory, agreements, contracts, and seminars related to these fields. A pleasure to have you here, Professor Hellman. Thank you so much for being with us. And last, we'll have Professor Sofia Moro, who has a PhD in law from the University of Toronto and director of PhD in philosophy from Harvard. She's studied on the discrimination and equality, as in a recent book, Faces of Inequality and Discrimination. He's presently professor of law and philosophy, director of reviews of publications of the Law Review and Journal of the university. Thank you so much for being with us, Professor Moreau. So we won't take any more time away, because as you can see, we have a very excellent panel. So we'll give the floor to Sandy Fredman to start with. Thank you so much, and you have the floor, Professor Fredman.
Well, thank you so much. It's wonderful to see you again and wonderful to be here. I'd like to thank everybody at the Center for Constitutional Studies, Mexico and the court, the president of the court. It's wonderful to be here as well with my fellow panelists. So thank you very much for inviting me, and I'm really looking forward to participating in this discussion. So what I want to do is talk about the right to substantive equality and a four-dimensional understanding which I've been developing over years and even decades. And in order to do that, I'd like to start with the journey that we need to take from formal equality to substantive equality. And although some of this is familiar and some of the obstacles are familiar, I think it's important for us to recognize, first of all, what it is that we are aiming at with formal equality, and then what are the limits and how we can move beyond those limits. And in particular, I'm going to look at formal equality from the Aristotelian notion of treating likes alike, and start by asking, well, why do we want to treat likes alike? What are the reasons for that? And then what are the limits that all of us who are fighting for the right to equality have faced in using this concept of treating likes alike in confronting the deep problems of inequality and how can we move beyond those limits. And this is the background for developing a four-dimensional notion, and particularly thinking about gender equality, but also referring to other bases of inequality, race, disabilities, sexual orientation, etc. So to start with what should be a familiar maxim coming from Aristotle, that equality in morals means this: things that are alike should be treated alike, while things that are unalike should be treated unalike in proportion to their unalikeness. And I like this picture because it immediately makes us ask which bits of what looks like two reasonably identical figures should be regarded as relevantly like and relevantly unalike. Does the fact that one has his toga over his right shoulder mean that it's relevantly different from the other one with it over his left shoulder? And I think that shows that there's a background value judgment that needs to be made right at the beginning as to which bit, what we are comparing, and which aspects of people's identity can and should not be compared. But coming back, we'll come back to that in a minute, but just to start off with looking at the aims of why should we treat likes alike. Well, in general law, it's a really important principle of consistency. We want similar situations to be treated similarly. But in discrimination law, we develop that by saying there's certain aspects of two people which should not be considered in the mix of what's relevant and what's irrelevant. And in particular, gender and race are irrelevant, so that what we really want to do is treat people on the basis not of these characteristics which are seen to be irrelevant, but on their individual merit. And this is behind the concept of direct discrimination or disparate impact, which is found in many jurisdictions, which says that we should prohibit less favorable treatment on grounds of race, gender, or other protected ground. Now, of course, this has really important virtues and benefits, and in many ways for women, for Black people, people of color, it's been a huge struggle just to get to the point of saying we should be treated on the basis of merit. But rolling out this idea of direct discrimination or like treatment didn't really change the underlying forces. And why is that? So some of the limits of treating likes alike immediately become apparent. The first thing is who is relevantly alike. And as in many jurisdictions, the question of pregnancy is a key example of this. In Canada, in the UK, in the US, women who were pregnant or people who were pregnant were regarded as sufficiently unalike not to be treated the same as those who were in the workforce, and were therefore excluded from the protection of discrimination law. So only by changing that, by saying, and by sort of social struggle, could we say that all the discrimination against people who are pregnant, predominantly women, should be within the scope of the right to equal treatment. But even if you are, if we do say that we should be thinking about likeness, the question is, why should we be alike? We may say that actually it's not so much difference that's the problem. The problem is the disadvantage attached to it. And certainly for women and for other protected groups, the need to be alike requires a kind of conformity which devalues difference. For example, needing to, you might say women can enter the workforce, but unless you change working hours for everybody so that everybody could share childcare, for example, the need to conform will not necessarily change the pattern of the workforce. And even then, is like treatment enough? When there's significant antecedent disadvantage, we really might need better treatment, not treat it, and we might need to say that the people who have been disadvantaged in the past need to be treated better. Fourthly, the whole idea of treating likes alike is agnostic as to the level of treatment. You could treat everyone equally badly and still fulfill this principle, or you could even remove benefits from some and level down. The well-known story of or the well-known case, I should say, of the swimming pool in the US town of Jackson, which was reserved for white people. And when the Civil Rights Act came in and it had to open up, well, it could not discriminate on grounds of race. Instead of opening up to all races, it closed down to all races. And there are actually lots of other examples in the case law about this. And finally, I think the whole point about merit really needs closer scrutiny, because it appears to be objective. It appears to be based on your technical achievements, stripped of your gender or your race. Here are you as an individual. But actually, what is stripped, when you strip away gender and race, you don't get an abstract individual. You usually get someone with the qualities of a middle-class white heterosexual able-bodied man. So it appears objective, but a lot of it depends on previous advantage, what kind of education you've had, what who you know, what your accent is. And so even the idea of merit, as important as it might seem, needs to be scrutinized. So in the journey from formal to substantive equality, what do we need from a conception of substantive equality, which will overcome these limits that I've just set out? So the first thing is that the questioning of the ideal of a gender-neutral, colorblind future, which is still very much there in many cases, say in the US Supreme Court or elsewhere, to say that we need to treat people regardless of their gender, regardless of their color. Actually, it's not so much difference that leads to inequality, but disadvantage. So the focus should be on disadvantage. And that means as soon as we say we're focusing on disadvantage, it doesn't make any sense to level down, because then you won't be redressing disadvantage. So it addresses that issue. It also means that we can be asymmetric. We can say that affirmative action is not a breach of equal treatment, but is a way of achieving equality once we are focusing on redressing disadvantage. And it also means that we can, well, the other thing we need to do, at least in a substantive conception, is to value identity, not to strip people away from their identities, which, if it wasn't attached to disadvantage, might well be a valuable part of your personality or your culture or your group, and to be able to value that and not expect people to conform to the dominant norm in order to be able to be part of the right to equality. And part of that too means that in order to value identity, we need to bring about, we need to recognize that a lot of inequality comes from structures, from institutions, and a much deeper structural change is necessary. And one important aspect of that is to say that this shouldn't be based entirely on fault. So one of the problems, the difficulties of anti-discrimination law based on a principle of like treatment is you often need to find a perpetrator who is at fault in the sense of having treated somebody less favorably than someone else, which is a very heavy burden on those who are trying to assert their right to equality. Once we see that it's about structural change, we know that it's not about a whole lot of individuals who are prejudiced, but about institutions in society, and therefore not so much the individual perpetrator, but those who are able to bring about change should be seen as being responsible for change. So then, thinking that we need to have these as our criteria for a substantive equality concept, what are the candidates? We may want equal opportunity or equality of results. The difficulty with both of these concepts is that equal opportunity could vary between simply removing barriers, but as a well-known statement of President Johnson was, you may open the gate but not be able to go through the gate. So really, if we are serious about equal opportunity, we really need provision of substantive resources. And that very rarely falls into the conception of equal opportunity. Equal results is also important, but it has vagueness in the sense of which results are we talking about? Are we talking about the results of education? Which could then be equalizing the starting point? Are we talking about the results of in the workforce? And also, of course, once we start looking at the whole population, does it mean that every segment of the population needs to have a kind of proportionate representation to how they are represented in the population? Very popular is the notion of dignity, which we find in the Universal Declaration of Human Rights. The inherent dignity is often linked with equality, as has also been stressed in the Canadian Supreme Court and in the South African Constitutional Court in many contexts. And there are lots of proponents of actually reducing equality to the notion of dignity. And that too has a lot to be said for it. But the problem is that dignity can be very vague. And there are lots of cases in which both the majority and the dissenting judgments use dignity to support their positions. And there's also a lurking problem with dignity in that some, even historically and even in current discourse, we sometimes find people being regarded as more dignified than others. So are we really talking about equal dignity, in which case we need equality back? Thirdly, the subjective objective issue is it how I feel or is it how I should feel? And in these cases, which were in the Canadian court, the UK court, and the South African court, all those courts took the view that if you gave lower social benefits to people in order to, say, induce them into the workforce, this was not a breach of their dignity because it was for their own good, whereas they themselves landed up being extremely poor and regarded it as a humiliation. So, and the fourth limit of dignity is that it's very individualistic, or at least in some formulations, it's about my individual dignity rather than me and my group, and how do we bring the social element of it in. So what I want to do in my four-dimensional approach is to try and draw on the strengths of all of these candidates for the right to substantive equality, but also buttress the weaknesses, as well as meeting the criteria for overcoming the limits of formal equality. And in that way, my argument is that it should be seen in a four-dimensional way. And these are dimensions. It's not a list with any kind of priority. They are dimensions because they buttress each other. And I'll just say them quickly, and then I'll explain them one by one in a moment. But the first is to redress disadvantage. So that brings in the asymmetry of the need to move beyond formal equality, but it also brings in equality, one of the strengths of equality of results, because it looks at the outcomes rather than the treatment. The second one is to address stereotyping, stigma, humiliation, and violence. And this is brings in, again, it resonates with dignity, but it's more specific than dignity. And the third, which is often forgotten, but really so much voiced by people who are stakeholders for the right to equality, is the need for the voice and participation of those who are involved. And the fourth is to bring in the notion of valuing identity, accommodating difference, but also bringing about structural change. And before I elaborate on each of these, I'd like to just quickly to say how they really need to be seen to be interacting with each other, so that the interactions between them are extremely important. And also when there are conflicts, a synthesis needs to be achieved. So the argument is that each of these dimensions needs to be optimized so far as possible, bearing in mind the need to optimize the other dimension. That's the concept drawing on Alexi's work. So what do each of these mean? Well, as I said, the redressing disadvantage focus, which is the redistributive dimension, is asymmetric. So it doesn't require a neutral, colorblind, gender-neutral future. It focuses on the disadvantage and the results, which means that there's no leveling down. Affirmative action could be seen as a means to achieve equality where necessary to overcome disadvantage rather than as a breach. But it's not enough on its own. So sometime in the development of this concept, I thought, well, why do we not just go for redressing disadvantage and not consider the other aspects of status of out groups or of status groups? But it very quickly became clear that it doesn't address the other issues like stigma and stereotyping, lack of participation or structural inequality. So we need the other dimensions. And the second dimension, as I said, redressing stigma, stereotyping, prejudice, and violence. This resonates with the dignity notion, but it's more specific in that it focuses on several parts of dignity which matter in this context. And importantly, violence is on the same axis as stigma, stereotyping, prejudice, and prejudice, because of needing the importance of showing that racist and gender-based violence is an aspect of the right to equality. This is a really important recognition in courts in various places, that it's not just about ordinary criminal law, but about the right to equality as well. The other thing about this is it goes beyond the individualism that dignity might bring with it. And that's why I use the concept of recognition, which comes from Hegel originally and more recently Nancy Fraser's work, because recognition is a social issue. It's about interpersonal relations. It sees identity as a social construct, and therefore situates stigma and stereotyping, prejudice and violence within social relations and individuals' social location, so that we can see from this and the first dimension that all through this runs the notion, the recognition of imbalances in power, that it's always about focusing on the less powerful rather than the more powerful within this status group. So that's this dimension, but it's also not sufficient alone. And this brings in the third dimension, which is about participation. An insight which came from very early on in US jurisprudence about that we need equality, or at least we need judicial intervention where political forces are not sufficient. So again, the notion of imbalance of power is brought into, so that the right to equality should cater for those who do not have voice and should facilitate the voice and the participation of those. But not only political, it should also be social and economic decision-making and even social participation. So one of the things that this resonates a lot with is age discrimination, where many old people are excluded from societies. So their participation is crucial, as with people with disabilities. And the fourth dimension is, which I call transformation, is that, again, the problem isn't so much that people are different. The problem is that they are treated worse because of their difference. And therefore, we need to go beyond conformism to change these underlying structures, such as institutional racism, such as the built environment, such as the male norm, and moving beyond individual fault, so that actually the right to equality can be the achievement of the right to equality doesn't entirely fall on the shoulders of those who are least able to assert it, but on the shoulders of those who are most able to bring about change. But as I said, these are dimensions. They are not a list. And so we need to, it's really important to think about how they interact with each other. For example, to think about how prejudice or misrecognition causes disadvantage. And a very good example of that is equal pay for work of equal value. The fact that women's work has been for so many decades and even centuries undervalued in the workforce is because of the stereotyping of women. And that causes their disadvantage because it lowers their pay. Until you deal with both of those, you won't address either of them properly. On the other hand, you might find that if you only focus on one dimension, you actually cause problems along a different dimension. So you could redress disadvantage, but you could reinforce stigma. And one example of this is from Social Security. You could call people who are recipients of Social Security scroungers, or taking advantage of their position. And that causes stigma, even if you are actually providing them with Social Security. So this framework requires both of these dimensions to be addressed simultaneously. And again, there could be measures redressing disadvantage, but which perpetuate structural inequality. An example is that for those of us who've been fighting for many years for the right of pregnant people and the right to maternity pay, very soon realize that unless we also get paternity pay, there will not really be structural change. So again, the redressing of the disadvantage by excluding women from the workforce is not sufficient until we bring about the structural change, which would redistribute the division of labor in the home. And fourthly, as one more example, you might accommodate difference, but you might infringe the recognition one. For example, you might accommodate people's religious needs while at the same time infringing on the recognition values in terms of gender or sexual orientation. So the reason for putting all of this like this is to say that all four dimensions need to be optimized simultaneously. So just to add that this model has now been accepted as a result of a submission that I and my team made by the Committee on the Rights of People with Disabilities, which is the Convention on the Rights of People with Disabilities, which has been widely ratified by many, many countries in the world. This is General Comment number 6, which was issued in 2018. And you can see that the notion of inclusive equality, which is set out in this General Comment, reflects the four dimensions: a fair redistributive dimension to address socioeconomic disadvantage, a recognition dimension to combat stigma, stereotyping, prejudice, and violence, and recognize the dignity of human beings, a participative dimension to reaffirm the social nature of people, and an accommodating dimension to make space for difference. And we had a discussion about that fourth one, because you'll see that the fourth one doesn't include as much about transformation as about accommodation. And I think the committee decided that they didn't want to go so far as to bring about, to advocate for, as this fourth dimension, actual structural change. And perhaps this is something we could talk about further. It's also seen in the Equality Act 2010 in the UK, this is the provision for positive action and affirmative action. And you can see again, as a result of submissions by myself and my colleagues, that they accepted the distributive, transformative, and participative dimension. And these are now the criteria for positive action in the Act. And most recently, the Indian Supreme Court, in the case of Nitisha against the Union of India, which was a case about women in the army who had, in order to become permanent members of the army, had to conform to the male norm in terms of their career trajectory. And in order to move the court to the constitutional understanding of the right to equality in the Indian Constitution from formal to substantive equality, the Indian Supreme Court again cited this four-dimensional model. So in conclusion, and this has been a very quick romp through a whole lot of issues, but just to say that the understanding of the right to equality in 4 dimensions aims to address the limitations in formal equality, to draw strength from other conceptions and avoid weaknesses, to create a structure which is mutually reinforcing, complementary, and thereby a framework for analysis of policies and practices in their ability to achieve equality. So I look forward to further discussion and also to the contributions of my colleagues. Thank you very much.
Thank you, Professor Fredman, for your participation, and I would like to give a floor to Professor Deborah Hellman now.
Thank you so much. So that was super interesting, and I think what I have to say is going to be a bit narrower in that Professor Fredman was talking about equality, and I think I'm going to be talking about the philosophical foundations of anti-discrimination law, which I take to be narrower in that I think prohibitions on discrimination are grounded in equality, and substantive equality, but I would go say that there are many features of things that substantive equality would require that aren't called for as a means of eradicating discrimination. So that's just to situate it. Also, I'll say, join Professor Fredman in thanking you all for inviting me to address this group. I'm really flattered and excited to be here. So thank you so much. And one tiny clarification, I don't want to claim a degree I don't have. The degree I have is a JD, not a PhD. And I don't want to pretend that I have that if I don't. So just to clarify. Okay, so I want to begin by asking the question about a feature of anti-discrimination law. So one important feature of anti-discrimination law is that such laws identify grounds, traits, or features of a person on the basis of which discrimination is prohibited. And that's something we see in all jurisdictions. They don't say, generally speaking, don't discriminate. Rather, such laws say that it's illegal to deny someone employment, for example, or refuse to lend money to someone on the basis of race, sex, religion, disability, and some, etc. They'll have a list of traits or grounds on the basis of which discrimination is prohibited. The form of these laws then gives rise to two questions. Why have a list at all versus having a law that says don't discriminate? And why have the particular lists that are common? Now, clearly there's some variation among them. All states don't prohibit discrimination on the exact same grounds. So we might also want an account that explains why that is the case. What I have to say today, and I'm sorry that I don't have a PowerPoint to aid with clarity, but what I want to talk about today has a negative component, that is, I want to argue against one view, and a positive component. I want to argue for two components. So first, on the negative side, I'm going to argue against the view that what matters is whether the trait is relevant or the discrimination is rational. So already I think you can see some similarity between my views and Professor Fredman's. And second, instead, I want to argue that discrimination law focuses on the particular grounds that it does because using these features to make decisions about a person is usually demeaning. And I'll say a bit more about what I mean by that in a minute. And secondly, so these are the two positive parts, because decision-making on the basis of these traits, the traits that are on the list, usually compounds injustice. So the normative foundation of anti-discrimination law on this view lies in our obligations not to demean others and to avoid compounding prior injustice. So let me start with the first point, which is the negative point, that rationality, or the rationality, or the arbitrariness, the irrationality, excuse me, or the arbitrariness of a decision or a policy is not relevant. So a common answer to the question, why do we pick out these traits as prohibited grounds of discrimination, is the following. These traits, race, sex, religion, disability, etc., are usually irrelevant, or because it's irrational, say, to refuse to hire a person, to use that example, because of her race, her sex, her religion. So that's a common answer, and that's the position I want to argue against. The first way I want to argue against it is that we might note that it's actually not true that those traits are, generally speaking, irrelevant, or that it would be irrational to discriminate on those bases. Unfortunately, it's often rational to use race and sex and other prohibited traits to make decisions. The reason it's rational is that past discrimination and other forms of mistreatment have made it the case that members of these groups often do have less of some trait that's relevant in the particular context. So, for example, members of these groups might have less wealth, which is relevant to a lender, or weaker skills, which might be relevant to an employer. So each of these traits might be a decent proxy for something that employers and lenders legitimately care about. This is a problem that anti-discrimination law needs to address rather than to deny. Second, and in a more philosophical voice, if you will, in my view, irrationality is not of moral concern. So this is really pushing against the Aristotelian treat like cases alike even further, I think, than did Professor Fredman. While in some contexts, people might be entitled to a rational decision, here I'm thinking, say for example, of the criminal justice context, this entitlement derives from demands of that context, not from a general non-discrimination principle. And it is this second point that I'm going to say a bit more about. The claim I want to make is that arbitrary decisions do not wrong individuals in virtue of their being arbitrary, unless you fill it out with some special circumstances. Now, arbitrariness is a somewhat ambiguous term. So let me surface a couple possible meanings of it. One meaning might be arbitrariness is a kind of unpredictability. Another might be arbitrariness as a lack of constraint by ex-ante rules. And a third might be arbitrariness as lacking a good reason. To make this discussion concrete, I'm going to focus on the employment context, and in particular, a private employer. As I said, there might be special reasons for the state to be non-arbitrary that I want to put to the side. So the question is, does a private employer owe a duty to prospective employees to be non-arbitrary in each of these ways? So let's first explore the idea that an employer owes a duty to prospective employees to be predictable. Well, that seems odd to me. After all, an employer ought to be able to change its goals, to change its strategy for achieving those goals. And in that sense, the employer could be unpredictable in what criteria it uses to select employees. The only caveat I'd identify here is sometimes an employer has announced a policy that will guide hiring. That is, I'm looking for an employee with this list of qualifications, and invited the employees to rely on that. That is, invited them to submit all kinds of materials that take a long time to produce that show that the employee has those traits. There, I think the employer might have a duty not to change what it values or what it's looking for, but it doesn't come from a general obligation to be predictable, but rather from having invited that reliance. I think a similar point could be made about the lack of ex-ante constraint. It seems to me a private employer is free to change its goals as it sees fit. The idea of arbitrariness as lack of a good reason seems more promising. But that asks us to say more about what counts as a good reason. Perhaps what we have in mind, and I think this is what we have in mind, is that it's arbitrary when an employer uses a hiring policy that doesn't serve the employer's own goals as it defines them. So for an example, suppose an employer is hiring a person to make widgets. Just use that as an example. It hires someone who's not good at making widgets at all, and you're better as a widget maker. You might claim that the hiring procedure is arbitrary, meaning there's no good reason to hire that person and not you, given that the employer has the goal of making widgets. Given the employer's own goals, it should hire someone who's good at making widgets rather than someone who's less good. This complaint seems odd also in my view. It's kind of bad business for the employer to hire someone who's less good at his or her job, but why should a prospective employee have a moral entitlement that the employer make decisions that are good for the employer? Or to put the same point in the lending context, it's sort of an odd complaint for the borrower, prospective borrower, to say to the lender, you have a duty to do what's good for you, to lend to the people who really are going to pay back. In other words, bad business decisions, which is what arbitrariness is in this context, are not discrimination. So I think we've made a mistake in confusing discrimination with arbitrariness or irrelevance, except in certain special circumstances where there's some other reason rather than a general non-discrimination norm. There's no reason for a moral entitlement for the employer or the lender to do what's good for it, which is essentially what the idea of merit-based hiring is getting at. So rather than say it's not adequate and we have to go further, which is what I took Professor Fredman to be saying, I want to say that it's not connected to non-discrimination at all. So now let me turn to the more positive side. What do I think are the normative foundations of discrimination law or not anti-discrimination law? Well, there's kind of a puzzle that lies at the heart of our prohibitions on discrimination. Laws and policies and practices and actions of private parties, state parties, etc., distinguish among people all the time on the basis of all sorts of traits. And clearly, sorry, I'm just going to wave to my light there. It goes off if you don't move. Clearly, much of that distinction drawing is morally unproblematic, but some of it is deeply problematic. And then, of course, there are instances that people disagree about. The puzzle of discrimination is to articulate when these policies that treat people differently fail to treat them as equals. I don't mean fail to treat them the same, I mean fail to treat them as people who matter equally. And my first answer to that question is when those laws or policies or actions are demeaning. Now, I obviously have to say more about demeaning, but let me flag one thing. I said a noteworthy feature of all anti-discrimination law is it has a list of prohibited grounds. So this account that laws and policies and actions are wrongful discrimination when they're demeaning provides an answer to that question, which is this. That discrimination law is organized around a list of protected traits because these particular traits are the ones that are most likely, when used to differentiate between people, to be demeaning. That doesn't mean they always are, but we single out those traits in our anti-discrimination law because they have the most demeaning potential, you might say. So what do I mean by demeaning? An action demeans, in my view, when there are two parts to it. So the first part is when it expresses denigration, that is, it expresses that the other person or group are not of equal moral status. So I call this the expressive dimension. It's about the meaning, the social meaning of the action. Is the meaning of the action one that expresses that those affected, those disadvantaged by the law, policy, or action are not of equal moral status? And the second part, which I call, so that was the expressive dimension. The second part I call the power dimension, looks at the entity or the person who is expressing this meaning, this denigration, and whether that person or entity has real social power. That is, I mean, whether that person or entity has the capacity to lower the social standing of the group or person affected. So I lay out this view in my book, When is Discrimination Wrong? And I'm not going to obviously go into everything about it, but I'll say a bit more. First, you might wonder, why think that demeaning is the moral concern that underlies anti-discrimination law? Well, I think it captures what we're worried about when we're worried about distinguishing among people. When we distinguish among people and we're worried that we might, when we draw these distinctions among people and treat some people better and some people worse, we might worry that we're failing to treat the people as equals, as people who matter equally, or with equal concern and respect, or something like that. So if the question that motivates anti-discrimination law is, when does this drawing of distinctions between people fail to treat them as equals, it provides an answer that connects to that. We fail to treat them as equals when we express that they're not equal in a context in which this expression could have real consequences for their social standing. The upshot of this approach, I want to focus on two dimensions of the upshot of this approach. First, the actions of powerful actors like employers, the state, etc., large employers, I mean, like big companies, anyone with social power, powerful actors are going to have more demeaning potential. It doesn't mean that an individual can never wrongfully discriminate because she can never be demeaning. Particular individuals can have true social power. It just means that bigger players are more likely to do things that are demeaning. And this helps explain why our law treats the actions of kind of big players often differently than small players. Secondly, when we focus on the expressive component, what does the action at issue express? We can see that differences of context and culture can matter. Certain kinds of differences in treatment have a social significance in some cultures that they don't in others. Similarly, differentiating on the basis of some traits may express something different in some cultures than in others. So here's one example, which I give in the book. The policy of many states in the Jim Crow America and the American South before the Civil Rights Movement was to require Blacks to sit on the back of the bus. When we think about that policy, we might compare it to a policy of today that of a school that has a school bus and requires teenagers to sit in the back of the bus. My account can explain why the first is an instance of wrongful discrimination, while the second is not. It's not that there's something kind of materially worse about the back of the bus. It's that the back of the bus has a social significance in the American South that it doesn't have in the same way today. And this gets to why we single out certain traits. Race has, especially in the United States, has more demeaning potential than age. Not that age has none, but telling Blacks to sit on the back of the bus expresses denigration, expresses that they're not of equal moral status, while telling teenagers to sit on the back of the bus doesn't have that meaning. This explains why the first policy is demeaning and therefore wrongful discrimination, and the second is not. Okay, a few aspects I want to highlight using that example. One is that determining whether we have an instance of wrongful discrimination is in part an interpretive question. That is, in order to conclude that ordering Blacks to the back of the bus constitutes wrongful discrimination, but ordering teenagers to the back of the bus doesn't, we're interpreting what the meaning of that action expresses in a particular time, in a particular country. It's an interpretive question in that sense. And as an interpretive question, there is likely to be disagreement. I view this actually as a positive feature of the account rather than a weakness. I think allowing us to see what we're disagreeing about advances the project and allows us to talk to each other in a direct way. When people disagree about whether something is an instance of wrongful discrimination, they're often disagreeing about how to interpret a particular action. Professor Fredman mentioned affirmative action, so I'll just highlight that, which is some justices on the US Supreme Court think that affirmative action expresses not denigration of anyone, of African Americans or whites, but rather is a welcome mat rather than a no trespassing sign. Whereas Justice Thomas has forcefully argued, I don't agree with him, but he's argued that what affirmative action does is it stamps Blacks with a badge of inferiority, suggesting that they can't compete without that patronizing indulgence of whites. So I don't think we can get rid of our disagreement about controversial cases like affirmative action with a theory. Rather, it can direct us to what we're disagreeing about. And my account allows us to see that what we're disagreeing about is what affirmative action actually expresses. And I'll end this part by saying, in my view, no person should have a privileged place in this interpretive exercise. Rather, we should all strive for an objective interpretation as best we can. Okay, so in part, I think that discrimination is wrongful when it's demeaning. The second thing I want to argue for positively is that we should also, that our anti-discrimination law is also grounded in the duty to avoid compounding injustice. Interestingly, those traits whose use is especially likely to be demeaning are also those that have been used to disadvantage people in the past. It's for this reason that their use is not irrational, as I noted earlier. Thus, anti-discrimination law's prohibition on the use of certain traits to distinguish among people also functions to avoid compounding prior injustice. And this is a good thing. the fact that an action will compound prior injustice, in my view, should count against doing that action. So let me say a little more about what I mean by compounding injustice. Let me give you an example. In the United States, a while ago, many insurance companies had a policy of refusing to issue life insurance to victims of domestic abuse. And they did this not out of animus toward abuse victims, but if you're being beaten up by your partner, you're more likely to be killed and to draw from the life insurance pool. So it was rational, if you will, to either deny coverage or charge higher rates for life insurance to abuse victims. Still, I think that policy strikes many people as morally troubling. For one thing, it's morally troubling because the insurer is entrenching or compounding the prior injustice. Not only has the abuse victim suffered violence, now she can't even get life insurance. So it augments that prior injustice. In addition, the insurer is mixing itself, is involving itself in that prior injustice in a way that makes it on the hook, in my view, or partly responsible for entrenching or compounding the prior injustice. It involves itself or mixes itself by using the person's status as an abuse victim as the reason to charge her higher rates. That's one kind of example. Let me give you another because I think it allows me to say something a little bit more. Imagine a girl, Aaliyah, who attended a school in a poor neighborhood where the quality of education was weak. The schools were substandard, let's say, due to an unjust distribution of resources. As a result, she lacks the skills sought by many employers. In this case, the employer doesn't reject her because she suffered educational injustice, as happened in the abuse victim case. Rather, it doesn't hire her because she lacks relevant skills. Still, the employer's decision compounds prior injustice. It certainly entrenches it. First, she got a bad education and now she can't get a job. But also the employer mixes itself with that decision because it uses the kind of immediate effects of the prior injustice as its reason for action. I call this the anti-compounding injustice principle. And in my view, compounding injustice, the fact that an action will compound injustice, is a morally relevant feature of an action that should weigh in the balance of reasons considered by an actor. When we look at anti-discrimination law, we can see, sorry, my computer is making some sounds. We can see that this feature animates our anti-discrimination law. It animates certainly the prohibitions on indirect discrimination, in that when an action produces a disparate impact on a legally protected group, we can say that's the compounding of prior injustice. And when the law requires that the actor, the employer, let's say, provide a reason for its policy, a good business justification, it's demanding a justification that can outweigh the compounding of the prior injustice. Also, it underlies direct discrimination because those traits, race, sex, and others, because they are predictive often of things that those actors actually care about, then the fact that the law prohibits the use of those, even when it's rational, is preventing the compounding of that injustice. They're rational to use because of the prior injustice. So just to recap, anti-discrimination law prohibits the use of a list of traits. Why? Not because the use of these traits would be irrational or arbitrary. In fact, it might be rational to use them. And importantly, arbitrariness and irrationality are not of moral concern. In other words, bad business decisions are not what's wrong with wrongful discrimination. States prohibit the use of certain traits because using these traits to distinguish among people is often demeaning, and demeaning is morally wrong. What is demeaning? Actions that demean when an actor with real social power expresses that others are not his or her equal. The second moral concern underlying anti-discrimination law is the duty to avoid compounding injustice. Anti-discrimination law does this both by prohibiting the use of traits that are likely to be good proxies for relevant other traits, precisely because of prior injustice against the people with those traits, and by requiring that policies that disproportionately disadvantage people with protected traits face a burden of justification. I'll stop there. Thanks so much.
Thanks to you. Excellent participation. And now we'll give the floor to Professor Sofia Moro. Thank you so much, Professor. You have the floor.
Thank you. Thank you, Jose. Thank you, Anna Maria, and to all for inviting me to participate in this terrific panel at the International Congress of Constitutional Law. I'm very grateful for this opportunity. So in my remarks today, I want to do two things. Firstly, I'd like to add to what Professor Hellman has said about the normative foundations of anti-discrimination law, and to offer some different considerations from the one that she has offered about what makes discrimination morally troubling and why certain traits should be thought of as prohibited grounds of discrimination. But then I also want to step back and talk for you a little bit about how the approaches of all three of us, Professor Hellman, Professor Fredman, and myself, might coherently be brought together as different parts of a single approach to eliminating discrimination and moving towards substantive equality. It's always good to come away from a panel having heard a number of individually interesting and stimulating proposals, but it's less helpful if you have no idea of how the proposals relate to each other and whether they can be implemented together. Although I have to say, I think it's wonderful how certain repeated themes, such as the inadequacy of focusing on arbitrariness, the importance of thinking about disadvantage and worries about compounding disadvantage are coming in in all of our remarks. So I will talk toward the end of my remarks about how I see in a sense, Professor Hellman's and my view in relation to Professor Fredman's view. So like Professor Hellman, I have focused a great deal in my prior work on the normative foundations of anti-discrimination law. That is, thinking about what it is that makes discriminatory policies and acts particularly morally troubling or wrong. So both the theories that I have articulated and Professor Hellman's theory can help us identify particular features of different discriminatory practices that wrong people and that give these individuals and social groups a moral claim on others to have these practices abolished or transformed. I, in the past, have defended a pluralist theory, but one that's united by the idea that all wrongfully discriminatory practices, in some sense, subordinate certain people to others or turn them into the inferiors of those others. And this is in ways that I'll talk further about in a minute, similar to Professor Hellman's view that what's essentially troubling about discrimination is that it demeans certain people. Now, I see Professor Fredman's four-dimensional approach as complementing these theories of what makes discrimination wrong and why certain traits should be treated as protected traits by providing important guidance on what we need to do in the future to rectify such wrongs, and as Professor Hellman said, to go beyond a state of discrimination to one in which groups have reached a kind of substantive equality. So I actually think that our views are in many respects quite compatible and that we need all three of them. You can think of Professor Hellman's and my views as helping to identify what has gone wrong in the past and what the problem is with our current practices. And you can look to Professor Fredman's view as a kind of roadmap for how we can prevent these wrongs in the future. So let me start now by sketching out an alternative to Professor Hellman's understanding of the normative foundations of anti-discrimination law. Now, it seems to me that what is really essential to wrongful discrimination, what makes it a particularly troubling sort of inequality, is that certain people are treated as the inferiors of others. So it's essentially a kind of status-based wrongs. Now, I would agree with Professor Hellman and Professor Fredman that not all instances of arbitrary treatment amount to wrongful discrimination, and that the arbitrariness doesn't capture really the source of the unique moral problem here. And that is because not all such treatment leaves some people as the inferiors of others. But as I'm going to try and suggest to you today, I don't think that the status-based wrong should be limited or understood as primarily as an expressive one. So in my view, it doesn't have to be the case that wrongful discrimination expresses denigration of others. And I want to urge that we focus more on a variety, in many cases, on a variety of apparently neutral social structures that don't send a message that denigrates anyone, but that nevertheless end up entrenching certain disadvantages and marginalizing certain social groups. Now, in my book, I discuss 3 ways in which an act or a policy can discriminate and thereby subordinate a person or group. I've spoken before to many of you. I gave a talk earlier this year as part of the Seminario Permanente sobre Igualdad. So I don't want to spend too long on this and bore those of you who already know my view. Instead, what I'm going to do is share my view and talk a little bit about some specific examples and ways in which I think we need to focus on subordination that goes beyond simply demeaning others. And then I also want to share with you a group of philosophical views that are actually quite different from Professor Hellman's and mine. They are, like ours, views about the foundations of discrimination law, views about what discrimination law is aiming to do, but they're quite different from ours in that they don't focus on status-based wrongs. They focus on other things. Okay, so let me turn to my view then. One way I think in which a policy or act can subordinate someone to others is by perpetuating a state of affairs in which one social group in a society has a status lower than that of others across a variety of different contexts. This is true here in Mexico, for instance, of the rural poor, of indigenous peoples, of women, and of course, these categories intersect in a variety of ways so that there are particular unique forms of subordination that indigenous women suffer, that rural women suffer from, and so on. Now, I think that in order to understand the ways in which particular discriminatory policies contribute to social subordination, it's very important that we look not only to whether a policy explicitly demeans someone or sends the message that they're inferior, but also to whether it contributes to social subordination simply by ignoring certain groups, rendering them and their needs invisible. Now, in my book, Faces of Inequality, I develop a word for policies that accommodate the needs of some while marginalizing others. Because I actually hired a research assistant to look into whether there was a word for this, because of course I didn't want to be inventing my own term if there was already a word. And strikingly, that there wasn't really a word that captured exactly what I'm trying to capture here. So I have used the term structural accommodation. The idea is here, these are real structures in the world. Sometimes they're physical things like the step up on a storefront or the flight of stairs. Sometimes they're not physical, but they're a very real part of our workplace. They're workplace policies. And they're accommodations not because they accommodate the needs of the marginalized group, but because they, in a sense, already accommodate the needs of the privileged groups, the needs of those groups whose needs have just come to define what is normal. Often they don't demean the few, they just don't consider their needs at all. So consider the policy that you're probably all familiar with through the pandemic. This policy was in my home province of Ontario, Canada, largely what our government did for the first few months of the pandemic. It had no other real ideas, so it said, stay home, stay safe. That was all it said. Now, this policy had a perfectly legitimate public health purpose. Obviously, it was designed to stop the spread of disease. But on its own, all it did was extend protections to the more privileged part of the population, those who could actually work from home. And it simply said nothing about those who could not work from home. They and their needs were just rendered invisible. And of course, they were already, these people, we're talking here about workers in stores, we're talking about essential workers in hospitals, the people who scrub the floors, the people who provide the supplies, ambulance drivers. They're already among the lowest paid and the worst protected workers in society. Now, as this example is designed to show, government inaction and indirect discrimination, and I'll talk more about this in a little, can play a huge role in sustaining social subordination. So I think if we're concerned to use anti-discrimination law as a means of eliminating the most pervasive forms of social subordination, we need to give tribunals and courts nuanced ways of thinking about how these things too can constitute wrongful discrimination and contribute to subordination. Part of what we need to do here, I think, is to start thinking about structural accommodations, what they are, who they exclude, and how they interact with certain persistent stereotypes in society about marginalized groups. We also need to think more about the various processes through which certain social groups and their needs get constructed as the norm and others get marginalized and not seen at all. Professor Fredman and I are both contributing to a project run by Rebecca Cook, which has culminated in a book, Frontiers of Gender Equality, Transnational Legal Perspectives, which tries to reimagine gender equality in international law. And the reason I'm mentioning this is that Professor Fredman has done some pioneering work in this book at looking at ways in which norms in the workplace marginalize women. There's a similar body of wonderful work by Caroline Criado Perez in her book, Invisible Women. She looks in detail at women's bodies in medical contexts. We're only really beginning to realize the ways in which women's health is being put at risk. Because of course, for years, both those who researched diseases and those who designed treatments simply assumed that the male body was the norm. Now, I think it's really important to note that when they assumed the male body was the norm, they didn't do this out of a desire to exclude women. And in a sense, it was done in a way that was thoughtful toward women. There were worries about including pregnant women in research studies. This might harm the women's health and so on. So it seems to be a bit of a stretch to try and rope this into our concept of demeaningness and say that the problem here is that this demeans women. I would just want to say the problem is that it silences women. It renders them invisible. It renders their distinctive physiology invisible. And what it thereby did was, of course, to then turn the different responses that women's bodies inevitably gave to particular forms of treatment or particular illnesses into idiosyncratic responses that became their problem, as opposed to being regarded as normal responses of a certain group that it's the medical profession's job to respond to and rectify. So that's what I wanted to say to you firstly about group-based social subordination. There are many discriminatory acts and policies, both instances of direct discrimination and instances of indirect discrimination, where the problem seems to lie in the fact that the policy contributes to perpetuating this state of social subordination, where particular social groups or particular subgroups within those groups are marginalized and rendered invisible across a number of areas of society. But I also think there are other ways in which a policy can make some people into the inferiors of others, even if it doesn't play a large role in perpetuating large-scale social subordination. So I want to just briefly sketch two of these for you. These are also discussed further in my book, Faces of Inequality. The first is that discriminatory policies can deny people a certain sort of freedom, which I have talked about as deliberative freedom. This is the freedom to deliberate about your life and decide what to do in light of your deliberations without having to treat certain traits of yours or other people's assumptions about them as costs, and without having to live your life with these traits always before your eyes. Now, we don't always have a right to deliberative freedom, but sometimes we do, and often discrimination can take that away from us. You can think, for instance, about the pervasive effects here of racial discrimination, how if you're a Black Canadian in my society, every time you go out on the street, you're watching, is a police car driving by? What's the policeman going to think of you? What are all the stereotypes about Blacks in light of which he'll reinterpret your behavior? You don't, in that context, have certain deliberative freedoms, certain freedoms that those of us who are white simply take for granted. Why is this a problem of discrimination? Well, the idea is that we live in societies where many people do have these freedoms and we all highly value them. So leaving one group of people without them is in effect treating them as second-class citizens. So the lack of deliberative freedom matters here because leaving people without it becomes a way of treating them as second-class citizens. And then thirdly, sometimes governments can leave a person or a group without access to what I have called a basic good. That is a good without which that group can't participate in society as an equal. And this too can count as wrongful discrimination. So for instance, to return to Canadian examples, because of our legacy of residential schools, which we're actually remembering today in particular on September 30th, there are many, many families living on reserves and off reserves that require far more resources for child welfare support than do non-Indigenous families. Given this history, I think we can say that this counts, this extra support counts as a basic good for Indigenous families, and not providing that counts as a form of wrongful discrimination. This account is actually quite radical because, as you'll probably be thinking, it does imply that leaving a group without a certain good can constitute a problematic form of discrimination, even if this is not explicitly the result of a particular act or policy that the government is currently engaging in. That's something that I believe quite strongly, but it is controversial, and I'm happy to discuss that further during our question period. So I've now shared with you a few different views about the normative foundations of anti-discrimination law. But what they share with the view that Professor Hellman articulated is they share this idea that fundamentally what's morally problematic with discrimination in the sense relevant to discrimination law is that it's a status-based wrong. In some way, it turns some people or some groups into the inferiors of others. But I wanted to note before you here that, of course, there are also other views of what makes discrimination wrong or morally objectionable that don't focus so much on the status difference between individuals or groups. So I wanted to talk briefly about a few of those views before I turn to thinking about Professor Hellman's and my view in relation to Professor Fredman's steps to take to move us toward substantive equality. So the other views that I have in mind about the normative foundations of discrimination law that don't focus so much on status tend, interestingly, to focus more on autonomy. I'm thinking here firstly of the views of the British legal scholar Tarun Kaitan. Professor Kaitan feels that what's problematic about discriminatory acts and policies is that collectively they prevent members of certain social groups, the most marginalized social groups, from having the conditions necessary to live an autonomous life. So he doesn't necessarily think that each discriminatory policy wrongs people by denying somebody's autonomy. That would be implausible, but the idea is that together these policies are problematic because they result in a situation where certain groups lack access to a variety of valuable opportunities that, if they did have access to, would enable them to pursue an autonomous life. And the point of discrimination law, on Professor Kaitan's view, is to fix this. It prohibits certain kinds of policies and acts, and in so doing, enables racial minorities, women, people with disabilities, religious minorities to access these valuable opportunities that without discrimination law, they wouldn't be able to access. A related set of concerns has been articulated by Professor Joey Fishkin from the University of Texas in his book on bottlenecks. He focuses there on the particular moral problem that he calls the problem of bottlenecks. A bottleneck is a narrow place through which many things have to pass and often get stuck. And his idea is that there are, in a metaphorical sense, bottlenecks in our society, places through which lots of people have to pass in order to reach a wide range of opportunities. But so far, many get stuck, many are unable to pass through them. So as some examples, for instance, he thinks that a college education in the United States is one of these bottlenecks. There are so many opportunities you can't access unless you have a college education, but there are so many barriers to getting one. Another thing, even more broadly, that he talks about is having enough money to navigate a society where everything requires money. This is something quite probably that takes us beyond discrimination law and into substantive equality here. But Fishkin's concern, like Kaitan's, I think, is with giving us enough opportunities to be able to construct an autonomous life for ourselves. The same is true of Benjamin Idelson, legal scholar at Harvard, who has argued that not in all contexts, but in certain contexts, the problem with discrimination and discriminatory policies is that they fail to treat people as individuals in the specific sense that they don't show respect for people's autonomous choices or for their capacity for autonomy. Now, as I hope I've made clear, all three of these views focus more on autonomy than they do on status or rendering certain people inferior to others. But like Professor Hellman's, in my view, their views of what renders discrimination morally objectionable, either in particular contexts or when we think of a group of such policies taken together and we think about their collective effects. Now, each of these views yields different explanations of why certain grounds like race, sex, religion, disability should be treated as prohibited grounds of discrimination. Perhaps these are traits that are most commonly used to subordinate particular groups. Perhaps they are, as Casper Lippert Rasmussen has suggested, socially salient. That is, they're just categories that have become treated as important in a wide variety of different areas of our social life, and therefore excluding or denying someone a benefit on the basis of one of these grounds has more of an impact on their social status than does exclusion on the basis of some trait that isn't socially salient, like the size of your ears. Or perhaps, as on one of these autonomy-based accounts, the protected grounds are best thought of as traits that are bound up with practices that together restrict certain groups' autonomy. Okay, I've sketched out my view now of the foundations of discrimination law. I've contrasted and also compared it with Professor Hellman's, and I've laid out a few others that don't focus so much on social status in the way that our views do. But I want now to try and link these views up with Professor Fredman's important work on moving us towards substantive equality. So I mentioned at the start of my remarks that I thought that Professor Fredman's approach could helpfully be understood as oriented toward the future. It's less concerned with drawing conclusions about how people continue to be wronged now, and more concerned with what concepts we need in order to build a future in which we can dismantle the many structures that either discriminate on the basis of protected grounds or simply continue to disadvantage and reinforce past instances of marginalization, and so prevent people from attaining a truly equal social status to others. So importantly, this difference between Professor Fredman's approach on the one hand and then mine and Professor Hellman's on the other isn't a difference that renders our views incompatible. We clearly need both types of approaches if we're fully to reach a state of substantive equality. My theory and Professor Hellman's theory help us to identify some of the particular features of different discriminatory practices that might wrong people or give these people a moral claim on others to have those practices abolished or transformed. And then Professor Fredman's four-dimensional approach, as I see it, provides guidance on what we need to do in the future in order to rectify such wrongs. Now, I see Professor Fredman's four dimensions as articulating the steps, some of the steps that we need to take if we're to eliminate the same kinds of wrongs that my pluralist theory identifies. When practices unfairly subordinate certain social groups to others, or deny them deliberative freedoms that they have a right to, or fail to give them access to basic goods, then clearly the only way in which we can rectify these wrongs is by doing the four things that Professor Fredman has said are crucial to achieving substantive equality. We need, as she says, to redress disadvantage, to address stigma, stereotyping, prejudice, and violence, and to see violence as a contribution to the marginalization of particular social groups. We need to facilitate voice and participation, and we need not just to accommodate difference, but also to transform the relevant structures. But I think it's important to note that unless we have a relatively precise view of why we're taking these four steps, we won't know what it is in a given context that we need to rectify. And relatedly, we need to be able to prove to the discrimination under discrimination law that there has been wrongful discrimination, or we won't be able to justify taking these four steps. So this is where Professor Hellman's and my theory, I think, are useful. And I think we can help in at least two ways. Firstly, I think because my theory and Professor Hellman's theory provide an account of what makes discrimination wrongful, they can provide the basis for convincing others that certain practices really are morally objectionable. They tell us that practices amount to wrongful discrimination when they impose certain kinds of harm on an individual or on a group. For instance, contributing to social subordination, or demeaning, or compounding past injustices, or denying people's deliberative freedom. So Professor Hellman's and my views encourage courts and tribunals that are adjudicating cases of discrimination to look for these particular kinds of harmful effects and to focus on the particular subgroup that is suffering from these effects. When you find them, then our theories give reasons for concluding that the practices are wrongfully discriminatory. But secondly, by focusing us on what is wrong with or morally objectionable about discrimination, our theories help to point in the direction of what in particular we need to do in order to transform discriminatory practices. So I think it's important to note that although, of course, we need to do the 4 things that Professor Fredman has noted, it's also the case that not every disadvantage needs redressing, not every stereotype is harmful, not every group needs a voice on every issue, and not every difference is relevant and requires accommodation in every case. So we do, in a sense, before we get to being in a position where we're able to implement Professor Fredward's framework, we need actually to think about what makes a particular practice objectionable. In the cases that Professor Hellman and I are talking about, is what makes it wrongful discrimination, who exactly is wronged, and it's only once we figure that out that we can then know which disadvantages require elimination, which stereotypes we have to challenge, whose voice we need to hear from, and which structures within our society need to be transformed. So I think that together, these approaches are very complementary, and I hope that together they will help you work through the problems that you see with lack of equality and discrimination here in Mexico. Thanks.
Thank you all, Professor. We have several questions, and we have around 6,000 people watching right now. So it's just like the Woodstock of philosophy, I would say. So there's no way we could answer all these questions, but we will take a few of them if you agree. So we will have 3 questions first and then 3 more. So the first question is, in Mexico and in several Latin American countries, there is a huge discrimination on the basis of poverty or financial status. So what are the agencies that would have to look at this disadvantage? Should it be the agencies that deal with the social and economic cases? So the second question, if you want to avoid the discrimination, do we have to make a distinction of categories of discrimination? And finally, the other question is, do you think that it is always prohibited to level down? Are there cases where it would be fair to worsen or to level down the situation of others in order to improve the situation of some? For example, by imposing more aggressive redistributive policies like taxing higher the people who will who pay more. So I would like to ask the second question in English. I will change.
So the second question is that in Mexico and Latin America, there's a strong discrimination against, well, for poverty and social class. And if discrimination law should take into account that as poverty as a category, or if we should use other institutions such as socioeconomic rights or something else to redress that kind of disadvantage. I'll switch back to Spanish, sorry.
I think he asked the first question. He did not ask the second question. So with this, I don't know who would like to take the floor first.
Okay, well, can I say something here? I think that's a wonderful question, and it's very, very important. I think we need both discrimination law and all sorts of other ways of trying to redress and address poverty. I do think it would help to recognize poverty as a prohibited ground of discrimination. In Canada, only the province of Quebec, which has its own Charter of Rights, has been able to do that successfully so far. What they have is they have a category called social condition, which means essentially impoverished condition. And that was done very deliberately because, of course, one problem that you get into when you try and recognize poverty as a prohibited ground of discrimination is people say, oh, does that mean we can never make distinctions on the basis of income? Our whole society relies on such distinctions. So at least if you think about it as the poor social condition that these people live in, that can forestall some of those objections. That's what I want to say, but I'm sure Professor Fredman and Professor Hellman have more to add.
Could I add to that? I just want to also say in advance about not wanting to claim a degree that I didn't have about the PhD as well. It's a BCL from Oxford. But just to follow on from what Professor Moreau said, I think one of the point to be made is what is the value added that discrimination law can add to what these other agencies are doing in terms of social economic rights or social security benefits. And again, the four-dimensional approach is helpful because what it says is that the disadvantage, socioeconomic disadvantage, when it is also stigmatic, and we know how stigmatic poverty can be, that it is often the stigma and the stereotyping attached to poverty that continues to entrench and perpetuate poverty. So where your address, where you live in a city, if you live in a poorer part, or if you don't have a housing at all, or you don't have clothing to wear to jobs, or you've been having poor education, it's important to see all these dimensions. So when we have socioeconomic disadvantage, the value added of substantive equalities, it makes us look also at the stigma and stereotyping, and also the lack of voice, because the poorer people are almost never the ones who have a say in who, and in power, in who makes decisions about their lives. And it's also the structural side, which is how poverty is entrenched in societies. So that's, I think, the point that, and I would entirely agree with Professor Moreau that they are complementary, but what the value added is to bring in these other issues, but also the asymmetric view makes it important, as Professor Moreau says, is that it's not just about your social and economic class, because we do have to have an asymmetric view and say it's about those who are the poorest and those who are the disadvantaged, not the others. Did you want to also ask about this, the second question about leveling down, or are we going to deal with that separately?
If you can answer the second question, that would be good as well, please.
Well, I think, again, the reason I raise at this point is that it's about the point isn't to say that that wealthy people shouldn't pay more taxes. They definitely should. In fact, the whole point of structural change is that those who can bring about change should. So those who are the advantaged group are certainly the ones who should pay more taxes. The leveling down point is more about removing a benefit from one group without giving any benefit to another group, so everyone is worse off. The other example to be given is retirement ages for women. So it looks pension ages for women, I should say. So the fact that women reach pensionable age at a younger age in many societies is kind of discriminatory in one level between men and women. But if you raise women's pension age to that of men's, then women lose out on 5 years of being able to draw their pension, and men don't gain anything. So that's the point about leveling down. The point is, if you remove a benefit from someone without that benefit being redistributed to the disadvantaged group so that everyone is worse off. Another example is equal pay. Very often, more and more, unfortunately, in bringing about equal pay for women, men's pay is reduced, but that isn't helpful, really. The important point would be to raise women's pay to men's so that men and women aren't in competition for, men aren't antagonistic to women's claims for equal pay, but also women benefit. Thank you.
Can I just add one thing? I don't want to talk too long because I know there's so many questions. So maybe to be provocatively controversial, I would say I actually am in favor of leveling down in many contexts. That is, it depends on what's at issue. And this actually relates somewhat to the other question about poverty, but imagine Professor Fredman used the example of this closing of the swimming pools. To me, what was wrong with closing the pools in response to an order to desegregate is that everyone knew that the reason they closed them was because they viewed it as horrible to have the races mixing in the pools, not because, and so that's what made it problematic. Without that, I don't think that it's necessarily problematic that now nobody can swim. In fact, if we're really concerned about poverty, maybe the right thing is that the state or the city shouldn't fund pools and should put that money into education. So a view that the response to the inequality can never be leveling down hamstrings the governmental agency about where it spends the money. And maybe the right answer isn't that everybody should get the benefit. Everybody wants the benefit, but some benefits aren't ones that I think are necessary for a good life. So I think it depends on what those are. So I think sometimes leveling down is not problematic and sometimes it is. Let me say one last thing and then I see Professor Moreau wants to get back in. But quickly about, I think I agree with the co-panelists and these presentations were all fabulous about the way to think about poverty. I think we are all thinking that kind of a both and, that is there's an issue that doesn't have to do with discrimination in being so poor that you don't have access to an adequate life. And that I see as not a discrimination issue. But then there's a second issue, and Professor Fredman said, what's the value add? And I agree that there's a value, an additional value in seeing the way in which poverty is stigmatized and poverty perpetuates itself. There are additional problems that are under the rubric of discrimination. So I think poverty is an interesting case where we have two potential things going on, a kind of wrong at issue that's not comparative in any dimension and a comparative wrong, and both are often in play.
Just a quick further point on the leveling down. I think that one thing we have to remember here, though, is that when the government levels down, it's never going to affect the privileged, or it rarely will, because the privileged have enough private wealth to be able to get these benefits privately. So if the government levels down by closing all the pools, that's not going to prevent the rich from swimming. They have private swimming pools, but the poor will be prevented from swimming. So I think when we think about this, have to think about the ongoing impact of private wealth and the fact that these government policies will most often affect the poor.
I agree with that. I just think that there still could be a decision about how to spend resources. Is it on recreation or something else that might be important?
Well, thank you very much. Let's go for the second round of questions. And we would like to thank you very much. And sorry when there was apparently a problem with the equivalence in education degrees. This question is directed to Professor Hellman. If inequality and discrimination cases are subjected to different interpretations, wouldn't the courts play or have a privileged role in terms of this interpretation? Because we know that judges come from privileged situations. You know, they're usually men from a privileged social case. So how can you reassess this context? Wouldn't this imply certain moral relativism? Because if construction is made on upon a certain position, then how would you see the case? Then the second question is, do you think that demanding COVID vaccination passport would be discriminatory given inequality of vaccination access in different countries? And the last question has to do with affirmative action. Do you think affirmative action such as gender parity in Congress is just accommodation? Because apparently some theories have a negative outcome because they are trying to right a wrong, but not that they are actually seeking non-discrimination. So thank you very much. These would be the three questions that we have now. And who would like to answer?
I'm not sure if they're all for me, but I'll take a cut. So the first one was about my sense that these are interpretive questions and the very real worry that the people who are going to be doing the interpreting practically are judges who are likely to be from a particular social class, more likely to be men, etc. And I think that there's a question about, there are two issues. One is, what is the right answer for how we ought to think about whether discrimination is wrong? And the second question is, given our institutional arrangements, are the people who are carrying it out likely to arrive at it? And that second point about who it is that has the power to make these decisions, I think is true no matter what theory you have. That is, there are problems with the fact that the people who make the decisions using any theory are from particular social classes and etc. And I think that is problematic, but I don't think it's solved by a different theory. I think it's endemic and something we should be concerned about. So I don't think my view invites relativism, because I would want to say that sometimes the judges arrive at the wrong answer because they're blinded by their biases, and that's unfortunate. And they can do that using other theories. There was the COVID passport, and the third thing was about, I actually didn't take a note, maybe someone, because I wanted to say something about the third one was.
Yeah, the third one was about, the third one was about affirmative action.
Oh, right.
How you can redress, how you can justify it if the theory or the main purpose of discrimination law is to redress wrongs instead of pursuing goodness. Yeah.
We're almost at the end of time, so I'll say one quick thing about affirmative action, and I'll leave the COVID passport because I think it's a difficult and neat question. About affirmative action, on my view, affirmative action is not problematic discrimination because it doesn't send a message, unless you make the argument, having women on boards or what have you, I don't think sends a message that men are incompetent. I think that argument has some traction in the university context, in the racial context, though I don't agree with it. I can see how it has something to it, but I don't see the argument that including women on corporate boards sends a message that men are incompetent. So I just don't think it's problematic as a form of, it's not discrimination, and so it's perfectly permissible. Okay, and sorry, apparently there was a problem with translation, but only the first question was directed to Professor Hellman. The other two were general, so yeah, you can chip in if you want.
So sorry, could you repeat the second question then? Yes, of course. I just missed that one.
Yeah, the second one is how can we justify affirmative action if, in theory, that try to redress a wrong, so that see that.
Oh, sorry, I got that one. What was the other one?
The other one was about COVID passport, I think. Yeah, sorry.
That one.
If that, oh, well, yeah, if requiring a COVID passport to travel or to access to certain services and goods can be discriminatory, taking into account that some countries have little or no access to the COVID vaccine. Mm-hmm. Yeah, that was it. Mm-hmm.
Okay.
Mm-hmm.
Could I say something about the affirmative action question? Well, the first one.
Yes, of course. Yes, of course. Whatever you want.
The first one really quickly as well, which is about judges interpreting. I think one of the functions of, certainly my theory, is also to make judges accountable in their reasoning to something beyond their own beliefs or biases. And it seems to me that the equal treatment principle and formal equality has allowed many of these biases just to be, in a sense, legitimated because of all the hidden things that go into saying treating likes alike. We are treating you alike, but the concept of merit is really based on a very much the perspective of the judge, or the concept of individualism, etc. So one function of having a four-dimensional approach is to require judges to justify their decisions on the basis of having to look at all these criteria. Does this policy redress disadvantage, or does it further advantage on? Secondly, is it stigmatic and stereotyping? Thirdly, is it against those who have less voice, or does it facilitate voice? And fourthly, is it structural? So it seems that, of course, we need to be dependent on the interpretation, but as lawyers, the more we can require some kind of structured reasoning around the right to equality or non-discrimination, the more we need judges to be able to have to, and lawyers and everyone in the decision-making process, including policymakers, to be able to justify according to a kind of evolving or developed standard of equality. On gender parity in Congress, I think it's important to think more about the difference between affirmative action in employment and affirmative action in representative structures. And because we're running out of time, and I'm sure Professor Moreau has got things to say too, one of the really important points is to include a variety of perspectives, and not that a legislature, which is a decision-making body, is entirely dominated by a single set of perspectives. Now, that's not to centralize women or to say that all women have the same perspective, because it shouldn't be, nor should it say that all gender representatives in a Congress, or women, I should say, should be representing other women as women. But it's just to say that because women's lives have been patterned by the discrimination, by the institutional patriarchy of society, there are perspectives which are not aired if there isn't at least a critical mass, but much more parity within a representative structure. That's it. In employment, it's about distribution. It's about, if there are half, 50-50 women and men, why is it that women are so excluded? Because there are discriminatory obstacles. And so affirmative action can really allow us to get over all the questions of proving prejudice and proving discrimination, and say, well, what we need is an outcome measure. And finally, the third point to make about that, though, is not to put too much weight on these affirmative action measures, because they often just redistribute privilege, not privilege, they often just redistribute those who are already better off gain the position. So it has to come together with much more deeply rooted transformative policies, which look at the most unequal, the least voice in society. Thank you.
Yes, perhaps I could just quickly add that I agree with everything Professor Fredman has said, and that, of course, one of the hopes in using affirmative action, both in the employment context and in the context of representative structures, is that we will then accumulate a critical mass of people who represent, who are able to understand the perspective of various marginalized groups without my meaning to essentialize that in any way, and thereby actually change the organization or our collective understanding of what amounts to merit in the relevant context. But obviously that takes a lot of people over a long time.
With this, we would like to conclude our session today. We were very privileged to hear you all today, and I hope that you can join us in the future. So today we would like to close our session. We would like to thank the attendees, and we would like to invite you to come to our next session of our Congress that will take place in Mexico City on October the 7th from 9 to 11 in the morning, Mexico City time. We will be discussing intersectionality. Goodbye. Thank you again.
Thank you and goodbye.
Good to see you all. Thank you so much.
Thank you all.